For centuries, people have helped their neighbors by providing food, shelter, and more to people in need. But all too often, government rules and actions block the creativity and generosity of ordinary people. That's why IJ defends those providing private solutions to public problems. Before we could post this episode, Kalispell, Montana, one of the cities we discuss, apologized. It agreed that the Flathead Warming Center had a right to its permit and could provide services to people in need. And cities across America are on notice that when they get in the way of safe and productive uses of private property, IJ is ready to fight back. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, with IJ Senior Attorney Jeff Rose. This is Beyond the Brief. So Jeff, what exactly do we mean when we talk about private solutions to public problems?
Sure. So what we're talking about is using private property and using the entrepreneurship of private people to help other people who are in need. And so it's the impulse towards charity, and it's protecting property rights, not just so people can use it to make money or take care of their own family, but to take care of others.
So recently, we launched a case in Montana that kind of shows this. Can you talk about that a little?
Sure. So we represent the Flathead Warming Center in Kalispell, Montana. It's a beautiful area. It's at the entrance to Glacier National Park. And even small to medium-sized cities across the United States, they have a homelessness problem. And so the Warming Center was started by a group of private individuals who raised private money to purchase a piece of private property. And they opened a place where homeless people could come and spend the night during the winter so they could get out of the cold. And after doing that for 4 years, the city decided to shut them down and did so without procedural due process, without paying attention to their constitutional rights as property owners and as social entrepreneurs. And so IJ stepped in to defend them.
This is Nonstop Local.
Welcome back, everyone. We're continuing our coverage tonight of the future of the Flathead Warming Center. It was announced at a press conference this morning that the Warming Center will be suing the city of Kalispell for revoking its conditional use permit last month. The center will be represented by a national nonprofit law firm called the Institute for Justice in this case. Our Taylor Richardson, he attended the press conference you just saw this morning and has more details tonight from the Flathead.
The Institute for Justice and the Warming Center are prepared to fight all the way to the United States Supreme Court to defend its private property rights and the rights of Americans across the country to do what Americans have done throughout history.
What was the city's sort of justification for shutting down the shelter?
It seemed to be that the city was fed up with the problems of public homelessness, which, in many ways we're sympathetic to. The public homelessness, people just sleeping on the sidewalks, that's not a tenable situation for any city. It's not a tenable situation for the people who are doing it. It creates all kinds of problems. And the city just seemed to be fed up with that. And so they chose the Warming Center as the symbol for that, or they thought that they were enabling people who are homeless, which is not true. And they decided to try to get rid of them in the theory that the homeless people in their community would mysteriously evaporate.
Yeah, it does seem sort of counterproductive to say, hey, we have a problem with homeless people being on the streets, so we're going to shut down the inside space that they can go to get off of the streets. Like, that just kind of doesn't make sense.
Right. We had a hearing in front of the judge, which we had live witnesses testifying, and sort of like a mini trial. And one of the things that came out is the city was frustrated that the city had closed the restrooms, the public restrooms, for example, and they were frustrated that there were homeless people who were going to the restroom in the park. And the judge and the rest of us were astonished to say, well, this is a place where the Warming Center is a place where homeless people can go and they can do the things that human beings need to do on private property. And it seems ludicrously counterproductive to shut them down.
Yeah, nobody wants to see waste on the sidewalk and stuff, but if you're getting rid of the solution to that problem, it's counterproductive. So we have other cases that are about homeless shelters and things like that. And most of those cases were about shelters trying to open. And the case in Montana is about a shelter that's already operating that the city's shutting down. Does that make it sort of legally different? Does that change kind of the approach to litigating that case at all?
Well, I think the big picture set of intuitions about the importance of property and the importance of preserving the rights of social entrepreneurs to take care of people in their community, that's all the same. But actually, the Montana case is a little bit different because the court treats I want to use my property in a particular way, and I am using my property in a particular way, is a little bit different. Once you start using property, particularly under a zoning code, you develop what courts sometimes call a vested interest in doing that. So once you're underway, it justify and you've invested a bunch of money and you've altered your property, it should be harder to shut you down.
Well, and I think that one thing that, we should emphasize here is the shelter had gotten a permit from the city and they were operating, according to the conditions of that permit, presumably. And so it wasn't that they just sort of started arbitrarily doing something and then said, oh, I'm already doing this, you can't stop me anymore.
Right. So the shelter went and got what is called a conditional use permit, which is a special permit you're required to do if you're operating a homeless shelter. And they weren't just presumably complying with it; they absolutely were. There wasn't even a suggestion that they were violating any of the conditions, nor had they even been cited or accused of violating any Kalispell ordinance. What seemed to happen is politically, people at least certain people within Kalispell, just were frustrated with homeless people out in public. And so they decided that the shelter was a symbol of that. And they decided to revoke their permit. And in some sense, this is exactly why we need constitutional rights that courts take seriously and defend, because the shelter discovered that it was suddenly a politically unpopular minority, and that in a completely political process that had none of the trappings of judicial protections, the city council revoked their permit to operate and effectively destroyed the shelter. And so we had to go to federal court, ask a judge to intervene to protect the shelter's constitutional rights. That is exactly what we do across our other cases. And our case here is a roadmap for judicial engagement on property rights that courts across the country can use, and not just in the context of homeless shelters.
When you say judicial engagement, what does that mean exactly?
So what that means is courts taking constitutional rights seriously, in this case, property rights. For a long time, generations even, the Supreme Court has suggested that when it comes to our property rights and economic liberty, the government basically gets a free pass. The only limit is the limit of the government's imagination. So if a lawyer can come in and kind of invent a hypothetical justification for a regulation of property, the courts are supposed to shrug their shoulders and say, good enough for me. Here, we filed our complaint, and the judge held within 2 weeks, within 3 weeks, the judge held a mini trial on our complaint. We heard evidence. We had the mayor testified, the chief of police testified. And then the judge wrote a well-reasoned, over 40-page opinion and granted us what's called a preliminary injunction, saying that the city can't stop our shelter from operating, at least while the case is going on. And it's that taking our rights seriously, not just shrugging your shoulders, not just rubber stamping what the government does. And that's really important.
So kind of putting my Keith hat on, there's a couple of other Supreme Court cases that seem like they might interact with this a little bit. So the first one is the Cleburne case from like the 80s. Can you explain a little bit about that case? And I know it's been important in some of our other homeless shelter work. Was it important here?
It was. And the nutshell on Cleburne is it is a famous equal protection case. And it was a case about a home for mentally handicapped people. And they applied for a permit, exactly the same kind of permit we had here in Kalispell. And it was clear that nobody wanted the mentally handicapped around. And so the city started dreaming up justifications for denying the permit that I suppose in the abstract sounded reasonable, like, oh, this shelter's going to be in a floodplain and we don't want them to get flooded out. But it turned out the city wasn't denying other people permits or construction things, even though they were on the same floodplain. And so the Supreme Court in that case said, hey, we've got to look beyond just the asserted justifications. And we should actually care when it seems that what the government is doing is just fencing out a disliked, unpopular political minority. In that case, it was the mentally handicapped. In this case, it's the homeless. So that is, and in fact, that is a case that we are reviving. And we have used it successfully in previous homeless shelter cases. And again, as with all IJ stuff, it's never just about this case. It is about using Cleburne to create and refresh a modern roadmap for courts to use when deciding property rights cases in a whole bunch of contexts.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to further support our work, consider visiting ij.org/employer-match to see if your company participates in corporate matching. Every match dollar goes further to protect the rights of IJ clients nationwide. Multiply the power of your contribution today. Visit ij.org/employer-match to get started.
So the other case is more recent, I think, from last term, the Grants Pass case. Can you talk about how that sort of interacts with what's going on in Montana and elsewhere?
Sure. So Grants Pass is a case that came out of Oregon. And the nutshell there is that some folks challenged ordinances that forbade sleeping in public, like in public parks. And they said that citing people for sleeping in a public park was cruel and unusual under the Eighth Amendment because sleep is a biological necessity. So human beings can't help but to sleep. And if they don't have anywhere to go, they have to lie down and go to sleep. And so you can't make that a crime. The Supreme Court said, look, cities have always regulated public spaces. They have always regulated right-of-ways like sidewalks, and it does not violate the Eighth Amendment to enforce basic laws about behavior in public spaces, which I think is fair enough. Certainly, I guess it's not necessary for cities to be gratuitously cruel in regulating their public spaces. They don't have to heap gratuitous misery on people who are already miserable. But I understand the impulse of saying these public spaces are shared spaces, and even people who are very, very much down on their luck, maybe they can't turn them into refugee camps or something like that. But there's an implication to that, which is if you can make it illegal to be homeless in public spaces, then it seems correspondingly that courts have to take more seriously the property rights of private property owners who want to allow homeless people to be on their private property. And that's what we have going on here. And we explained that to the judge as part of our legal argument in the Kalispell case. Said, like, fair enough, Kalispell has done all of these things that criminalize being outdoors. The shelter is on private property. It is run by private people using private money, providing shelter to private citizens. And under Grants Pass, the flip side is you've got to take these rights seriously, and the court agreed.
So you talked earlier about a preliminary injunction, and you said that means that the city can't really, enforce against the shelter while litigation continues. That seems like a pretty big deal. Is that common to get one of those?
No, it's not common for two reasons. Number one, in general, preliminary injunctions are hard to get. You have to be able to show to the court, one, you are likely to win on the final merits of the case. And then number two, that if you let the government enforce the law while the case is going on, there could be some kind of irreparable harm. And then, so that's just generally hard. Then number two, in property rights cases, in which, like I say, for generations, the Supreme Court has said, at least under some interpretations, all the judge really needs to do is shrug his or her shoulders and break out the rubber stamp. It's really hard to get a preliminary injunction. And but we got it. So that was excellent. As a matter of fact, one of the cases we used is there was a recent preliminary injunction case about protecting bears, grizzly bears in Montana. And one of the points we made is that if you can get a preliminary injunction in order to preserve the lives of bears, then surely we're entitled to a preliminary injunction to protect homeless people from freezing to death in the winter.
Wow, that's interesting. I didn't realize there was a case about bears.
Bears are a big deal in Montana, by the way.
That makes sense.
Yeah.
I understand that.
Yeah. They like them in three forms: stuffed, alive, and also carved in wooden sculptures. They're all over the place.
Yeah, there's those like little bear things standing in front of people's cabins and stuff like that. this is a fully tangent question,
Yes.
but my mom sent me a couple of weeks ago an article about a case in Colorado, and the headline was that elephants didn't have standing to sue about their release from a zoo or something. It ended up being, like the mechanism for the case was some sort of habeas thing or something. And it was just wild. And my mom sent this to me and she's like, how can elephants not be able to sue about their own thing? And I'm like, because they're elephants, mother.
That's true. Well, how could they not have standing? They have four legs.
Exactly.
Well,
also that.
It's true. Well, the law is complicated, and the law
It's a
of
weird
standing is
tangent.
exceptionally complicated. So too bad for the elephants. But hopefully there's a human being somewhere nearby who can perhaps take care of them.
So what is sort of the breadth of this work that we have in the sort of private solutions space? Is it all homeless shelter cases? What does the rest of it look like?
Sure. No, it's a variety of things. We have cases involving people sharing food. And so it might be sharing food in a public space, like going to a park and just sharing food with people who don't have very much. It doesn't mean they're homeless or anything like that. And you see these cases pop up every now and again, like where a church might show up somewhere and, church members will hand out, 100 sandwiches to people who want sandwiches. And, the government will have various reasons. We have a case in Arizona, for example, where, a grandmother was serving food to the needy. So that's just it's as crazy as it sounds.
Now to a national story that is making headlines in our state. A 78-year-old woman is fighting back after she was arrested for feeding homeless people at a public park. Police in Bullhead City arrested Norma Thornton because of a new city ordinance restricting the sharing of public food, or the food in public, I should say. Norma says that she's been feeding people at the park since 2018, but didn't have the money to get that newly required permit, which would only be good for one day out of the month.
I don't see it so much as an act of kindness or any great thing. It's just what everybody should be led to do. Love your neighbor. Love your neighbor as you love yourself.
And then we have other cases that have little food pantries where people have set them up almost like free libraries where people come and, pick up books in your front yard. Someone might have a refrigerator or some other things where they have canned goods and people just come and pick them up. And so, again, the sort of big picture is we want to be able to defend the private property rights of people to use their property charitably, which is something that has happened since ancient times, but also is deeply embedded in American history and tradition. Like when you think of the Underground Railroad, for example, that was shuttling escaped slaves north to freedom. Well, there wasn't a real railroad and it wasn't underground. So what was it, right? These were people who they would get to sleep in barns. They would say, here's a loft up there, go hide up there tonight. And then, the next day I'll show you how to get to another farm 10 miles down the road and you can spend the night in the back bedroom there. You can imagine a modern bureaucrat with the checklist and a pencil sort of tapping it and saying, oh, you know what? The shed where the escaped slave is sitting isn't a dwelling unit under our zoning code, and therefore they're not allowed to stay in there. That kind of thing. But in fact, people have been using their property to take care of other people since America became a country. And it's only in recent times that we've decided to subject that to 10,005 regulations.
Yeah, one of the sort of themes to me of all of this work is that people are sort of endlessly creative in solving the problems around them. And government is kind of consistently, most generously kind of unsure how to handle that situation, but maybe less charitably has kind of a reflex to say that anything it hasn't itself contemplated is just kind of automatically illegal. Right.
And, this is the special contribution that IJ can make in this area, because I think it will come as a surprise to no one that, trying to, there's no such thing as solving homelessness, frankly. It's just endemic to the human condition, it seems, but at least managing it in some reasonable way, in a humane and reasonable and cost-efficient way. That's something that we think of as what the government does or the government is supposed to do, or that it's exclusively the province of, kind of more liberal side activists and that kind of thing. But actually, there's this real space out there for property rights oriented constitutional lawyers and constitutionalists like IJ and IJ supporters where we can take that impulse towards human charity and compassion, something that's been part of the human story for millennia, and create a legal space for people to be as entrepreneurial with their charity as they are entrepreneurial with their businesses. And I think that's great for IJ to be able to contribute in that area.
So just to wrap up, what's next for the Montana Warming Center specifically?
Yeah, so we're in the process of discovery, the extremely unglamorous and frustrating process in which we exchange documents and evidence. And then sometime in the fall of 2025, we'll start writing briefs in the case. And maybe there will be a trial or the lower court will make a decision. And then we'll see, once we win, whether or not Kalispell will appeal.
Sounds great. Well, good luck with the case. Thanks for coming in.
Yeah, I appreciate it.
Thanks again for watching. Make sure to like, subscribe, and tune in for more videos.